Today is August 18th, 2021. It's right before 4 o'clock p.m. in Dallas. Yesterday, when I was reviewing legal information that was in book form, a book which, by the way, is identified as being printed by a company that has very comprehensive holdings, including what used to be, at least, a reputable journalistic endeavor that is also associated, at least currently and for the last year, with an alleged energy paradigm that I contend is involved in very illegal activity. Um, One of the things that was discussed was dates around contracts and at what point it was determined that a contract was in delinquency and the specific implications of the year and a day standard, right? Which has a different context in a civil case than in a criminal case, for instance. And last year, on this day, I identified some information that was available online about changes to the law in Texas. And one of the things that is in the changes that I understand has relevance after seeing the information I did yesterday has to do with prosecutors, and specifically a change that took place on September 1st of 2019, compensation of certain prosecutors. Except as otherwise provided by law, a district attorney or criminal district attorney is entitled to receive from the state annual compensation in an amount equal to at least 80% of the state annual salary as set by the General Appropriations Act in accordance with Section 659.012, paid to a district judge with comparable years of service as the district attorney or criminal district attorney. This is from Section 4 1.013. I've seen this before. I've seen this before in the last 2 years, right? And that 20% difference is very substantial. As a matter of fact, in early June of 2019, before this would have gone into effect, but perhaps after it had been passed by the legislature, there was a 2080 split involving a case that was at the time pending before the Supreme Court of Texas that I contended at the time was being used as part of an illegal hedging strategy. Now, in what is available online, there is Section 41.006, Report to Attorney General. At the times and in the form that the Attorney General directs, the district and county attorneys shall report to the Attorney General the information from their districts and counties that the Attorney General desires relating to criminal matters in the interest of the state. Yesterday, on the online version, there is specific information regarding the criminal prosecution for acts of securities fraud, up to and including acts of securities fraud involving bonds that would have to be authorized by the Attorney General, that is missing from the online information that is available in the actual books. Which means that any licensed attorney or prosecutor would have access to those libraries that for some reason the rest of us are not supposed to have access to, that have the official law. So you know that bond fraud is actually a criminal offense. You know that material misrepresentation of information connected to an area that is in the process of attempting to issue a bond is a criminal offense. You already know that, right? You also already know that there was a request, or rather a demand put forth, that the last three attorneys general outline a process that they understand can be engaged to provide a formal audit of any bond they've authorized under the auspices of attorney general. That would then mean that prosecutors in the attendant districts and district's attorney in the attendant districts would be in a situation where they would be apprised of bonds that would have a material implication on their capacity to perform their duties. Now, nobody responded, and nobody even put public information about how such a process could be engaged, but it just so happens before midnight last night, which would have been a day after the time frame wherein it was required. There's actually literally a specific process that is potentially engageable in Texas for that very thing. It involves intercession with the Office of the Comptroller. It has a very specific relationship with the Attorney General. But insofar as right now, the electronic records available online are intentionally misrepresenting the law around the criminal implications of securities fraud, I am letting every single district attorney and prosecutor that would be subject to section 41.006 know that you are also required to provide reports regarding any information in your district that would be eligible for criminal prosecution in accordance with understanding material misrepresentations have been provided that would have an impact on any bonds within your municipality or within your district or within your county. It's right here in the law. Is this accurate? Is this accurate? Because I already know you, of course, would know that by law, the attorney generals were actually in a position where they could very easily have engaged that process, and it could already have been accomplished. That means John Cornyn, that means Greg Abbott, and that means Kenneth Paxton. Now we're also in a very precarious situation because insofar as the Constitution has been abused, and allowing for laws that are absolutely unconstitutional to be put into effect. And insofar as, in accordance with that, there is a intentional abrogation of laws regarding the state budget, which cap any sort of derivative processes used in accordance with performance of the budget at 5% and no more, then we got a very important matter that needs to be addressed and officially opined on so that it can actually provide a standard regarding section 2252.093. Non-compliance creates void conveyance. A conveyance of property subject to this subchapter is void if a governmental entity fails to comply with section 2252.092. 0.092 is identification of trust property required. There is a substantial matter in this state related to property in trust, including specific implications regarding the kinds of trust that have been made available, including insofar as the last session that went into effect on September 1st of 2019, as well as laws that went into effect in May, June, and July of 2019 are involved. If we are in a time period right now where the solvency of the state has been put in peril because of a refusal to address crime as crime, and insofar as that is the case, there is some effort to try to mitigate the damage or try to engage in some process that is actually unconstitutional in order to further cover up for the criminal culprits, and that needs to be stopped immediately. My contention is that's exactly what's happening, and that the evidence of that mounts on a daily basis. We are in Texas. So far as we understand, Texas is still subject to the Constitution of the United States. This isn't a proxy out and swap yourself because you defaulted on your debt to somebody else, and then use the Texas system to try to create some paradigm there for which you won't be held accountable. No, that was never appropriate and never acceptable. These are literal matters, and we have a very substantial time frame ongoing. We need to deal with this very, very soon. Why? Because I right now in my possession have prospectuses regarding bonds that have been issued under the watch of Governor Greg Abbott and under the watch of alleged Kenneth Paxton that I contend are absolutely 100% illegal. Which means somebody approved them, and which means somebody allowed for them to be offered up, to be purchased, so that the illegal terms of those bonds, as this goes on, are being invoked by whoever it was that was allowed to purchase them. Some of those bonds are in the northern Texas area. You guys should already have known that. The governor should already have known that. The legislature should already have known that. And certainly the office of the attorney general should already know that. It is by law required that the attorney general review every bond that is to be put on the people in the name of any political subdivision within the state. That means every single bond issued in Texas under the watch of that attorney general falls on that attorney general.